When I was in law school, I couldn't get a job. I had 882 resumes that I sent out. You didn't do it by email back then. You actually sent the letters. I got 11 job interviews and I got 2 job offers.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Hello and welcome to Between the Briefs, brought to you by Steno. I'm your host, Adrian, and I'm here with my co-host.
I'm Joe Stevens.
And we're thrilled to welcome Neel Chatterjee, a distinguished partner at Goodwin Procter. Neel is a leader, or Goodwin Procter. Neel is a leader in the world of technology-driven litigation with extensive experience representing some of the biggest names in the tech industry, including LinkedIn, Facebook, and NVIDIA, in complex, high-stake disputes. Neel is widely recognized for his strategic and forward-thinking approach to intellectual property law, particularly in the technology and internet sectors. Beyond his legal expertise, Neel is an advocate for diversity in the profession and has made significant contributions to the community through his work on nonprofit boards. Neel, welcome to the show. How are you doing today?
I'm doing great. Thanks for having me.
Of course, man. It's great to have you on. Really happy to see you here. Now, you have a fascinating background, so I just want to get right into it. What can you explain to the audience about your journey, from working in the lower levels of a law firm to now being a partner at Goodwin Procter?
Yeah, so one of the things that I sometimes tell young law students is when I was in law school, I couldn't get a job. I had 882 resumes that I sent out. You didn't do it by email back then. You actually sent the letters. I got 11 job interviews and I got 2 job offers. And one of them was in Tupelo, Mississippi, and the other was in Denver, Colorado. And when I started at the firm in Denver, Colorado, literally the day or two after I started, they announced that they were going to close the law firm when it was, when you were a second year law student, that they were going to close when it was over. And, I've been very fortunate to work on great cases and develop a great career. But a lot of people just kind of think you walk in and you get like some job in big law or some, that you're this academic superstar and money's falling out of the sky. But for me, it was a little different than that. It was kind of earning your way in.
You tacked onto that, Neel. I saw you did a couple of clerkships, some judicial clerkships there. I teach at a law school here as well on top of practicing, and that still seems to be sort of a prize thing that obviously is not available to everyone. Is that something that you think is still important? Is there things that you drew from your judicial clerkships that you still carry with you?
Yeah, totally. And, when the law firm in Denver tanked, I had a regional tie and I used it to try and say, get a job in the state court clerkship, which was a very unusual thing at the time. Like those were things that people didn't really seek out. They weren't as hard to get. And then I worked for a federal magistrate in San Jose afterwards who I had met as a first-year law student. But I felt like working for the Colorado Supreme Court, which is my first clerkship, was really a seminal moment in my career development. And part of it was because the judge who I worked for, who's the junior justice at the time, later became the chief justice of the court, and now she's in like the Colorado Women Lawyers Hall of Fame. She graduated from Harvard Law School at a time when women didn't go to law school. She was one of the first graduating classes, and a lot of law firms wouldn't interview women. And she always kind of viewed it as her commitment as hiring people who'd be interesting to get to know and then mentoring them along the way. And I really don't think law school taught me how to write. I think she taught me how to write.
Wow. That must be so monumental, having someone that is in your corner and able to teach you things. How do you feel lucky, or do you feel like that experience really molded you into who you are today, having like a mentor that can teach you the ropes?
Yeah, it molded me in a super material way. I mean, this whole concept of, you know, like work with people who are interesting to get to know is like a fundamental thing. Like I founded the Bay Area Diversity Career Fair in California, or in San Francisco Bay Area. And I've always made that part of my hiring strategies for people. And then, you know, like Justice Malarkey, she was very much of the view of, look, you know, there's going to be a lot of people who are going to say, you know, like, I've never met an Indian lawyer before, or you talk without an accent, or, you know, those sorts of things that just come up. And she said, if your work and your ability is exceptional, no one's going to be able to second guess it. And that was always the view she had. And, you know, she also had a view that if you can't write a legal opinion in maybe 10 or 12 pages or less, it's too complicated for people to understand. They're gonna see too much gray area about how the rules should apply. And all of those things were pretty fundamental to everything that I do today.
Neel, if we pivot a second, let's talk about that. I mean, if you go back to those days when you were having to really sit down and reason through a 10, 12 page opinion, okay, putting it together, the ability to do that now, the technology that exists now to assist in that process is obviously staggering. I mean, it's the things that do you reflect on that? I mean, do you think about, are you conscious of those sort of technological changes and how they're applicable today? Or do you reflect on what it would have been like if you had that technology at a time when you were really learning how to reason?
You know, that's a good question. I remember when I was clerking, like they had a library in the basement, and I'd go down there and have to look at the old books and, you know, open them up, dust off the, you know, whatever, and go find these old cases. And then, you know, we did, I can't remember if we had the, you know, like the Windows operating system in the way that it is today, but it certainly is a lot easier to research and find case law today than it was back then. And it definitely, like, we would have produced, you know, a lot more work product a lot faster.
I'm curious, what are you currently using to get through case law? What kind of technology have you found really sped up your game?
Yeah. So, I mean, I'm still kind of old school. Like I you know, I still like Westlaw a lot, and I like natural language search a lot. You know, sometimes people will use Google. I use it a little bit, but I find Google's a little more unreliable. Certainly, you know, at times I'll go use ChatGPT on some things, but you got to second guess it, right? You got to look at the actual case of the result that it gives you and kind of, you know, evaluate those things, because it's not always reliable. And then we are doing a pilot with Harvey, which is a legal research tool.
Neel, do you think that this is something I'm always interested in. I mean, your career has spanned some pretty powerful technological introductions, like the sort of broad-based use of the internet, now AI, right? But to learn the way you learned without having, you know, all of that assistance immediately at the ready, I guess my question is, do you think that that's created a skill set in you that that young lawyers right now might not be developing the same way?
Yeah, you know, when I was, I think when I was in 7th grade, my dad bought a Commodore 64. Like, you know, it was like a keyboard with a computer in it. And ever since my dad was a computer guy, like he was an engineer and everything. And ever since I was little, like we were always kind of pushed to use technology in whatever we were doing in life. And I think it allows you to be a lot more nimble in adoption of new technologies. Although I have to say, as I'm getting older, I kind of get a little more set in my ways, you know? But I think at some level, people today, younger people, sometimes rely too much on technology and trust its accuracy too much. Like, you know, we have the Michael Cohen thing where he submitted a ChatGPT brief and all the case law was wrong and things like that. And I do think that happens a little too much. And I also, when it comes to brief writing, like, I have cases now where I'm in front of judges who are 80 years old, right? And they still want to have paper copies of things. I feel like brief writing, when you're looking just at your screen and you're not actually considering an entire work of authorship, it definitely has degraded some.
I want to ask you about your work with these high stakes brands, right? Such as Facebook, NVIDIA. What is a common misconception people have when it comes to working with such large companies, such as those?
I would say, well, so when you go to court, the biggest misconception is that all of these companies have everything organized internally, right? They think like these companies, they're big companies, they organize everything in rows and columns, and they have file folders for every little thing. When, I mean, these companies are moving fast. I remember I had a case where there was a company that put storage limits on how much any individual person could like store their emails and with their work and stuff. And so a lot of the engineers would go out and buy hard drives. And so like when you were trying to collect documents, you'd go into their little cubicles and they'd have like 50 hard drives in there. The workarounds were there keeping track of stuff. And like, what's that thing from Jurassic Park? Like they'll always find a way. Like this assumption that these companies are highly organized and that everyone follows the rules, the dots the I's and crosses the T's. That's just, that's just not the case, right? And, a lot of these big companies, like it's not utter chaos, but it's also like, it's hard to find stuff sometimes.
Neel, with those big companies, with the work that you're doing, they're obviously so heavily scrutinized now for a number of reasons, right? And not just like the role that they're playing in the evolution of our society, positively and negatively. Like, to what degree do you participate in that? Do you consider that? Are you aware of that? Or are you sort of about to give me, a good lawyer answer where you just kind of go to work on the case that you're retained on? I mean, does it matter to you that there's sort of a lot of public discourse and political discourse around these companies?
It matters a lot. And the reason it matters a lot is because when you go into a court, you're representing, some hot startup company that maybe has a little bit of press or maybe no press. There isn't an opinion formed about that company. Right. But if you're going in front of a jury and you're talking about, some big name company that, people encounter all the time, they're going to have good opinions or bad opinions, but they're going to have opinions because they're recognized, because they recognize it. Like, I've never represented Google, but, in the Bay Area, people are going to have views of Google. I had a case involving Stanford University in the Bay Area, and I went and did a jury focus group on it. And, people have opinions of Stanford University. They had opinions of Hewlett-Packard. Overall, Hewlett-Packard was very positively viewed. And those opinions can affect how jurors make decisions. It can affect how companies make or how judges make decisions.
That is a very big deal. And I'm wondering, you have to be very good at storytelling then to give a good frame of how you want the discussion and the thought process to be in regards to your case. What are some of the techniques you employ when it comes to storytelling?
Yeah, so that's a great question. So one of the things that I do when I'm talking about storytelling, like in patent litigation, like most people find patents very inaccessible things, right? They kind of think they're really hard technology, the words aren't familiar to them and things like that. But the way that a patent became a patent, the way that the patent claims, which are kind of like the metes and bounds of an invention, there's a story behind it. There's a story behind people who are inventors and kind of making it accessible of why was this an important thing for someone to do, is really kind of a central part to help people understand the context, and things that aren't accessible can become accessible by giving a context of what's the problem they're trying to solve.
On the heels of that, Neel, have the sort of the skill sets, maybe, I don't know what the right thing I'm looking for here is, but maybe it is the skill set of a younger IP lawyer, someone who wants to run into that practice? Has that evolved over the last 10 years, or has it sort of stayed remarkably consistent?
I think it's evolved. I think it's evolved because what is in technology areas, what is accessible to human experience is totally different. Like when I started practicing law, you couldn't have no one had an iPhone, right? You barely had, just phones or cell phones. And now if you want to talk about an app, people know what an app is. Or if people want to talk about TikTok, people know what TikTok is. And the way that information is consumed, younger lawyers can often give context to that. How quickly the information is consumed, the way that you consume it. Like I use in opening statements and closing arguments in cases, I use a lot more multimedia and things like that because people have a hard time listening to a person talk for, an hour or something. And that's all stuff that younger lawyers kind of contribute to. Like, Neel, that was great, but it was so boring. Like let's get a couple images in. Let's have some influencer type things thrown in and stuff like that.
Well, can I just follow up on that? If that's the feedback they give you, or let's say that's a generational feedback they might give you, flip it around. Like what are they doing when they sort of put together an opening statement or a closing argument where you kind of have to go back and say, okay, this, what is your feedback to them more commonly?
Yeah, my feedback to them, I would say the most common thing is that the way people reach answers is different than the way people get taught. So like if you write a paragraph, like a very common thing for people to do will be accordingly or thus at the end of a paragraph. And really what's going on when people write that or when they speak it is they're going through their chain of analysis of how do they defend whatever that paragraph's about. And I say, that's great when you're writing it because you don't know where you're going when you're writing, the paragraph or the brief or whatever. But the reader doesn't understand that you're going through this journey when you're writing things. And they're struggling when they're reading it in the same way you were struggling when you wrote it. So you got to take that accordingly or thus or that last sentence and put it first because like it's really important at the beginning to say, what is your point? And then you want to kind of defend it with the analysis underneath. That is like not every, but a very large number of first year lawyers, they give you, work product and it's very well done. It's written well and all those things, but you're kind of struggling with understanding like, what are they talking about? And then finally you get to the end of the paragraph and you're like, that was a lot of work to get there. And that, putting that last sentence first just makes an enormous difference.
I'm sure you've improved the process of working with your associates, all of your peers, even in your law firm. What would you say has really contributed to efficiency right now with the way you work, especially with those like associates, paralegals, so on and so forth?
Definitely the like Zoom and the remote kind of conferencing tools and things like that has increased efficiency. Because you can just jump on a call and, kind of talk through something. That has made an enormous difference. Research tools is super helpful. We process enormous amounts of information through e-discovery and things like that. Like I remember when I first started practicing law, I was like a senior associate on a huge case. And we drove 5 semis on Christmas Eve to, someone else's office and, dropped off papers. Now it's done with a click of a button, right? Like that's a hell of a lot more efficient.
Neel, do you have when we talk about, obviously AI is such a hot button issue right now, and it participates in conversations in every way from like efficiency, cutting out busy work, allowing you to do things a little bit more creatively, whatever it might be, all the way down the road to we're not going to have jobs it's going to render lawyers sort of irrelevant. It's going to hollow out the profession. Paralegals not going to have whatever, the doomsday sort of view of this. Where do you fall on that spectrum?
So like I've heard this refrain before. Like I've been around long enough that I've heard the refrain, like e-discovery or, all these things are going to, or not reviewing every single document, right, is going to kill the industry or these sorts of things. What I tell young lawyers is I say, if you're in big law, let's just generically speak of big law, and you're a second year or third year lawyer, you're getting paid, you're billing out at maybe $900 to $1,000 an hour, right? Crazy high rate. And the number one thing that you're being paid for on that is your exercise of judgment. And these tools help you do your job better and more efficiently. But every time someone says some new technology is going to be the death of lawyers, the legal industry has grown, but the expectation of what the lawyers can do has gone up. And the way I look at it is, yeah, AI is going to remove a bunch of things lawyers traditionally did. It absolutely will. But the output of that, whatever the AI is doing, is still going to be something that lawyers are going to do and are going to need to do, and they're still going to need to be their exercise of judgment. And I believe the industry is going to grow. It's just another tool. I mean, it used to be we went to the old law books and go to these giant libraries. Now we use natural language search and Westlaw, right? And that makes us a lot more efficient. But we still do what, the industry has still grown. There's still demand.
I'm curious on big pushback we get here is it will increase the output and lawyers will become more efficient, but the fear of the billable hour will then become kind of non-existent, right? How can I bill for all these hours I used to when I just did all this work in 30 minutes? So what do you think is, what are your thoughts on that?
Well, I just think people are going to, like the nature of the work is going to change, right? There's still going to be a lot of work to do. It's just the nature of what you're doing. Like I said, you're a third year associate, you're billing out $900 or $1,000 an hour. If you're doing grunt work, that is not value creation. Like there is a disconnect on, the value created by the billable hour. And I look at like something like AI as being something that creates more value for each of those hours. And those tools are necessary, right? And I don't think it's going to make the industry go away. It's going to make the industry change in what we do, just like e-discovery has or online legal research.
What would be like a specific change that you can envision?
A specific change would be like in merger and acquisition due diligence, where you're going through a million contracts that the company has to see if there's any warts, right? Like AI can go through and say, here are the non-standard things that are in here in a much more efficient way than humans can. That would be an example. Site checking briefs for accuracy of quotes or things like that. If someone's mischaracterizing a case, you'll be able to do that a lot faster. I am not sure if AI is going to be able to identify hot documents or not. I think in some cases it might, like in a litigation. I think in some cases it might, but in other cases it might not. I'll give an example. I had a case, and this was almost 20 years ago, and there was a technical word that was really important in the case. It was a really important technical word. And it was what everyone was fighting about. And I went back to the lab notebooks, and I found that someone had, when they were using that word, they had put it in quotation marks. And when I realized it was in quotation marks, I went to the inventor guy and I said, why is it in quotation marks? He's like, well, we made the term up. And that just completely changes the way that you look at patent law interpretation when someone makes the term up. Like he's like, I didn't have a word for it, so I put it in quotation marks and everyone started using it. Okay, well that's a pretty important thing. I'm not sure if AI would have caught that, right? A word was just put in quotation marks.
How is it possible that you can just kind of make up a word? I mean, I guess it's how language develops, but how does that go into interpretation patent law? Like if it's just kind of made up, seems a little, rough.
Yeah, well, there's a doctrine in patent law that says a patent holder can be their own lexicographer, which is they can write their own dictionary. And the reason for that is because sometimes when people invent things, there isn't a word for the thing that they've invented. So they have to coin a term to give it meaning, right? And because there isn't a way to describe it, so they come up with their own word to describe what it is.
Patent law has always sort of existed. I don't know. Maybe this is true of lots of practice areas, but patent law to me has always felt kind of inaccessible, right? I mean, it seems like the lawyers come from a sort of very unique backgrounds, very like engineering mindsets. Is that still true? Like, is this still where the path to that kind of work?
Well, so there's certainly a body of people that believe that it is this inaccessible thing. Everyone's got to be an engineer or a PhD in pharmacology or whatever. And there are people that believe that. The majority of the industry has moved in a direction of you kind of need a little bit of both. Like, I go to the DMV and I say, these are my jurors. And the reason that I do that is because I have no technical degree, right? And I am the person who's struggling to understand these hard technical issues, but I can make it accessible to lay people because I'm one of them. And sometimes, if you have the PhD, you speak at not always, but sometimes you speak at a level that's much more inaccessible because of the way you've been trained. And so, if you want to seek and obtain patents, you need a technical background. But if you're litigating them in court, it's good to have them around. But, like medical malpractice, right? Medical malpractice is all about what doctors did in the human body. That's hardcore science. No one ever said a lawyer couldn't talk about those things if they didn't have an MD. And, I think this patent law concept at some level, it was like patent attorneys in the old days wanted to, save their own jobs. So you created this misnomer about it. But, as lawyers, there's all kinds of industries where people are doing these technically complicated things.
I want to know more about what you think about the landscape today with big companies and where you see the law kind of embedding itself in it. Where do you see the biggest risk is for the future when it comes to these giant corporations that you represented in the past?
We all see it in the news, right? It's the consolidation of power. It's the consolidation of power where, some of these really large companies are a fairly small universe of people. We saw it in the 1920s to 1940s, but then, that really spread out, quite a bit. And now we do see a lot more consolidation of, entire consumer lives.
Seeing it grow. And that definitely poses a lot of risk.
Yeah.
Neel, let's go back to, it's sort of a career spanning question here for a second. Seeing all these different tech revolutions, I guess, throughout your career, is there any sort of legal strategy that worked back in like the 90s, late 90s that would be catastrophic today, or vice versa, something that is that you're seeing evolve now that's useful that might have been beneficial or catastrophic back then?
It's a good question. Something that would have been catastrophic back then. Well, certainly the way you talk about things, right? Like just the use of language. Like I remember I handled a case involving it was an internet law case involving discrimination against same-sex couples. And it involved adoption rights. And one of the groups I worked with was the Transgender Law Center, which was a very small kind of legal nonprofit about transgender issues. Back then, we were very cautious about how we characterize things in cases about gender discrimination or about marital rights, because at that time the marriage cases hadn't come out of the Supreme Court. And we were mindful of the fact that the judges may feel a particular way about what was a very controversial issue at the time. Today, transgender rights are kind of a fundamental part of our dialogue. It's more a question of, what kind of discrimination is it, or is it something that's actually actionable and things like that. 20 years ago, if you had brought in a transgender issue, you would have really had some challenges. Normally it'll be around those kinds of controversial issues. Like I worked on a case in the late 90s involving implants for marital aids. And then Viagra came out and it killed the whole, the whole implant market. And, how you talk about these issues really can be, significantly different. I remember I had a case where a number of companies were having problems where people were storing, let's say, unlawful or illicit porn on their systems. And I went to these large companies and some of the CEOs and I said, you should forge partnerships with legitimate porn to rat out the people that are hurting the industry. That was maybe a catastrophic thing I could have done, right? Like when I raised that issue, like, these legitimate, big companies are saying, wait, you're telling me to forge relationship with the porn industry? And, like that just feels wrong, right? And today, I don't think people would think that's too strange, because there are definitely people that are trying to comply with the law, and the people that are not, they feel like give them a bad name. So, those are some examples.
Sounds like you've been in a range of cases, and some bizarre, some incredible. Is there anyone that sticks out to you throughout your career and you're like, man, this was obscure, but a great story?
So the one that I like telling people, Adrian, is very early in my career, I was working with eBay. And eBay was maybe 30 guys on the second floor of a building down in Campbell, California. And they didn't have their own conference room. They shared it with another business that was in this little office complex. And I'm down there, and they have a lawyer who'd been practicing for maybe 3 years and a law student, and that was pretty much their legal department. And I'm sitting in there, we're in this meeting, and this guy that looks like a Canadian Mountie walks in, and we're all kind of sitting in this shared conference room, and he walks in and he gives the lawyer a document, and the guy looks at the document, and it turned out it was a person from the U.S. Fish and Wildlife Service. And he says, someone's trying to sell a duck on eBay. Do you guys know if we can sell ducks?
That's amazing. That is truly amazing. What was the answer?
Well, so, like the issue for eBay, right, is eBay doesn't actually touch anything that's part of the transaction, right? It's just a thing for people to exchange goods. And so there's a statute called the Communications Decency Act, which you hear about a lot today, involving social media and things like that. And the answer is that you're not allowed to sell a duck, but eBay isn't responsible when people do that. eBay is just a venue where people, exchange a transaction, but because they don't touch on it, unless it involves a federal crime or certain intellectual property rights, they're generally going to be immune. And it is really, the eBay work that we did was really foundational for a lot of the way internet stuff happens today.
That's amazing. Neel, I'm going to ask kind of just a personally curious question. There's a million reasons I think that IP law is obviously foundationally important to the world and to society at large, that I think a lot of people just don't know. Is it true? Like, is America a wonderful place for an IP law practitioner? Is it a really healthy environment? Do we do things really well here, or is there sort of like another country where it's actually, it may be more of a model place to actually do this kind of work?
So I will say that, like, as a litigator, if you are a small inventor and you're getting screwed, someone steals your invention, trade secrets, patents, whatever, it is very hard to assert your rights, because the cost of litigation in the United States is very, very high. If you go to someplace like Germany, it's not a perfect system, but it's definitely more cost effective to deal with IP disputes. The IP scheme of protection in the US is pretty good. Like, I mean, you can do all kinds of things to protect your rights, but the ability to enforce them when someone's taken your stuff, it's just, it's crushing for a lot of smaller companies. And there's a whole industry that's now developing called litigation funding that all they're doing is trying to help those people that can't get into a courtroom. extract a very heavy price for it, but they try and help people who could not otherwise file claims or afford claims to go to court.
Interesting.
Yeah. Well, Neel, this has been a fantastic conversation, and we always ask this at the end of our podcast. What is your hottest take on the industry right now?
My hottest take on the industry right now, I've got to say, is DEI. It is, it's a very hot button issue. I got my first job through a diversity job fair. I fund, I give a scholarship for first gens in law school. I founded the diversity career fair in the Bay Area, and law firms are trying to figure out what are the right words that they want to use to support people of different ethnic backgrounds, different socioeconomic backgrounds, different LGBTQ and women. But they also, it has become a controversial issue as of late. And when I think about what's occupying a lot of mind share in law firm leadership, it's going through, all of the pictures and all the ways you talk about these things and making sure no one's going to come after them. How do they fund diversity scholarships? How do they improve accessibility? You could even go to things like pro bono work and things like that, where, it feels like there's a different set of vetting going on where people aren't really sure. They still believe in what they believe, but they also don't want to get, in trouble.
Mm-hmm.
And, in a post Dobbs decision, for women, like how law firms talk about how they talk about abortion rights, and are they going to take a position or are they not? It just I've never, when I started as a lawyer, you didn't kind of think about the Republican and the Democratic law firms, and now people kind of do.
That is a hot take. Well, thank you so much for joining us here today. This was an incredible conversation. I thoroughly enjoyed it. Joe, any last words for Neel?
No, likewise. Neel, fascinating. As always, thanks for your time and your insight. It's just been wonderful.
Yeah, thanks for having me. I really, really appreciate it.
Of course. And for all those in the audience who have tuned in, thank you so much for tuning in. And of course, we'll catch you on the next one. See you soon. Up next on Between the Briefs.
I've wanted to be a lawyer since I was a child. Probably not for a good reason. I watched Law and Order, and I thought lawyers made a lot of money. I took trial ad in law school. I absolutely loved it. Loved the competition of it. Loved the excitement of it all, and the anticipation of what the result would be.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.